Hello everyone, welcome to Law School. Today we'll understand the difference between FIR registration provision under Section 154 of CrPC and Section 173 of BNSS, that is Bharatiya Nagarik Suraksha Sanhita. This difference came after the case of Imran Pratapgarhi versus State of Gujarat 2025 Supreme Court. Now, what is the case is all about? Why this is in news? You know, recently Supreme Court have explained the difference between FIR registered under old law and the new law and explained the key difference between both of them. The case came after the Imran Pratapgarhi, a Rajya Sabha MP, against whom a FIR was registered for sharing a video of a poem. He later on challenged the FIR. Then the Supreme Court have explained the provision of both the laws, that is BNS and CrPC. Now, what does old law says? Section 150 of CrPC. It states that if someone gives information about a cognizable offense like murder, rape, or etc., the police must write down it orally. If it is there in the oral form, then the police or inspector will write it down in the written form, get it signed by the informant, and registered an FIR. The key provision was no preliminary inquiry is allowed. If we talk about the older law, CrPC section 154, no provision of preliminary inquiry is there. So that means the FIR is mandatory in every case which is cognizable in nature. Later on, in the case of Lalita Kumari, the court had already said that earlier FIR is mandatory if a cognizable offense is. Means no matter what is the punishment of the offense, if it is in the cognizable nature, then police have to register an FIR. Now, what's about new law? Section 173 is a similar to Section 154 of CrPC. FIR must be registered if cognizable offence is reported. That means earlier the provision of FIR were there in the section of 154 of CrPC, but in the new law it is there in Section 173 clause 1. The provision of both the sections are same, but there is an exception to general rule in Section 173 of, that is, what does exception state? First of all, the exception is there in Section 173 clause 3. This is an exception to clause 173 clause 1. What does Section 173 clause 3 state? If someone report a cognizable offense punishable with 3 to 7 years of jail, the police can do a preliminary inquiry before registering an FIR. That means if an offense which is of cognizable nature, and suppose the punishment lie between the 3 to 7 years of, then the police has right to do a preliminary inquiry before registering an FIR. But there is also a and key provision is required, that is, if police wants to do preliminary inquiry, they have to take the permission from senior officer, that is minimum rank of deputy SP. Now, what is the purpose of this preliminary inquiry? Why do the police required to do preliminary inquiry in the case of 3 to 7 years of punishment? The purpose is to check if there is an enough reason to proceed. Means they want to clarify that if a FIR is registered in such cases, that it should be checked through preliminary inquiry that there is a prima facie case. Now, why this change matter? Why are we talking about this case? Why? Because earlier the CrPC does not require any kind of preliminary inquiry. But later on, if you talk about the BNSS, there is a provision of preliminary inquiry in the case of 3 to 7 years of punishment. Why do we require this? This is because let's first check if the case has a merit. In a medium serious cases, they want to check whether there is a case, the case is serious, the case is real or not, or some person is, filing a false case or frivolous case on a to harass someone. So to check that, the provision of section 173 clause 3 is given. Now we'll come back to the original case. For suppose there was a case of Imran Pratapgarhi posted a poem. Police, without having a preliminary inquiry, have registered an FIR. But the offence was punishable with the less than of 7 years. So under BNSS, the police should have done a preliminary inquiry first with the deputy SP permission to check if there was a real case. So if there is a provision in new law regarding preliminary inquiry, police have not done that preliminary inquiry. So the Supreme Court have questions the FIR and have asked to do a preliminary inquiry and explained the difference between the older provision of CrPC, that is section 154, and the new provision of BNSS, that is section 173, and stated the difference between the older FIR and the new FIR. Thank you for watching.